Okay, good afternoon, everybody. Thanks for coming by. Today's debate is going to be live streamed and video recorded. If you don't want to be live streamed or video recorded, then please take a seat over here where you will not be picked up by the camera or sound. Unless you're seated there, you've given your consent to appear wherever today's debate may show up, in the media, on the internet, wherever, okay? With that, let me welcome you. This is the fourth and last seminar this year in the University Seminar Series on Internet Freedom and Governance. I'm Lance Hoffman, Director of the Cybersecurity Policy and Research Institute here at GW, and my co-organizers of the series are Don Nunziato in the School of Law, Arturo Carrillo in the School of Law, Will Youmans in the School of Media and Public Affairs, and Susan Aronson in the Elliott School of International Affairs, all professors here at GW. The topic of the debate today is resolved that the government should never engage in the bulk collection of personal data for national security purposes. I want to thank our sponsors who are shown on the screen up here. We have financial support from the GW Provost's Office for the university seminars. We have some financial support from the Microsoft Technology and Human Rights Center. We have technical support and live streaming from the Internet Society, and our media partner, the Christian Science Monitor Passcode, their online modern field guide to privacy and security. It and the Internet Society and CSPRI are all live streaming today's debate at their respective websites. If your cell phones are on, please silence them now. If you're going to tweet during the debate, we ask you to include the hashtag up there on the screen, GWIFG, in your tweets. Finally, as we start, let me give a short shout out to Intelligence Squared. The inspiration for this came to some extent from the I-Squared debates. We're not associated with them in any way, but that series of debates about the issues of the day was the inspiration for this debate here. You can see their debates on all sorts of issues at intelligencesquaredus.org. Okay, briefly, the tensions between national security and civil liberties are obvious in a post-9/11 world, but the basic question is not new. Controlling the actions of persons in positions of power has been discussed by Plato in the Republic and ever since then. Today's debate is on the topic: the government should never engage in the bulk collection of personal data for national security purposes. It's going to take place in two rounds. And then our live audience here at GW in Washington, D.C. will vote to choose the winner. So now let's meet our debaters. And by the way, the live audience here, you should have been given 3x5 cards to cast your vote on, which you'll do in a few minutes, on whether you are for the motion, if you will, against the motion, or undecided. We'll come back and talk to you later about that after the discussions are over. Okay, starting now, Lee Tien is a senior staff attorney with the Electronic Frontier Foundation. Lee is over, wave Lee so people can see. He specializes in free speech law. He's published articles on anonymity, surveillance, the First Amendment status of publishing computer software, and information technology and children's sexuality. Lee got his undergraduate degree in psychology from Stanford and his law degree from Boalt Hall at UC Berkeley. Over to Lee's left, your right, is Chris Soghoian. Chris Soghoian is the principal technologist and senior policy analyst with the American Civil Liberties Union. Chris was an in-house technologist at the Federal Trade Commission, where he worked on investigations of Facebook, Twitter, MySpace, and Netflix. Prior to joining the FTC, he created the Do Not Track privacy anti-tracking mechanism that's now on the major web browsers. He has a master's degree in computer security from Johns Hopkins University and his doctorate at Indiana University, focused on the role that third-party service providers play in facilitating law enforcement surveillance of their customers. Oren Kerr, next in the middle, is a nationally recognized scholar of criminal procedure and computer crime law. Before joining GW's law faculty in 2001, he was a trial attorney in the Computer Crime and Intellectual Property section at the Department of Justice. He was also a special assistant U.S. attorney in the Eastern District of Virginia. He's a former law clerk for Justice Kennedy of the Supreme Court. He's testified 6 times before congressional committees. A couple years ago, Chief Justice Roberts appointed him to serve on the Advisory Committee for Federal Rules of Criminal Procedure. Orrin, and I didn't know this until I read this yesterday, has an undergraduate degree in engineering from Princeton and a master's in mechanical engineering from Stanford, but he has a law degree from Harvard. And finally, last but not least, is Paul Clark. Paul Clark is President and Chief Technology Officer of Secure Methods, LLC. His expertise includes network systems and security, cryptographic applications, certification, key management, authentication, and integrity strategies. Dr. Clark was previously Chief Scientist for DynCorp, where he was the architect and lead implementer of a system that allowed digitally signed and encrypted submission of tax data over the internet. As a member of the Federal Advisory Committee for Key Management Infrastructure, he served as chairman of the Interoperability Working Group for Cryptographic Key Recovery. Paul's undergraduate degree is in math from the University of California at Irvine. His doctorate's in computer science here at GW. Full disclosure, I was his thesis advisor. Arguing for the motion, the government should never engage in the bulk collection of personal data for national security purposes, are going to be Lee and Chris. And arguing against the motion are Orrin and Paul. Now, this is a debate. There's going to be one team winning and one team losing. And that decision is going to be made by you, our live audience here in Washington. By the time the debate has ended, this audience will have been asked twice to vote, once before the debate and once after. And the winning team is going to be those whose numbers have changed the most in percentage points between the first vote and the second vote. So let's register that first vote now. You've all been given cards. Which card are they using, the red or the tan or the blue or what? The yellow one? Okay. Vote on your yellow card whether you are for or against the motion right now. The government should never engage in the bulk collection of personal data for national security purposes. Okay? If you're against it, if you're for it, check the agree box. If you're against it, check the disagree box. If you're undecided, check the undecided box. Okay, please pass the cards over to the center aisle, if you will, and we'll have people coming down to collect them. Okay, just pass them over to the center aisle, and people will come down to collect them. And where are my, there they are. This dashing, these two guys here. Okay. Okay, let's move on to round one. Round one has opening statements. They're going to be 7 minutes by each debater in turn. Again, the motion is the government should never engage in the bulk collection of personal data for national security purposes. And here to argue first in support of this motion is Lee Chen from the Electronic Frontier Foundation. Lee, you want to use the podium? Yeah.
So thanks to Lance and GW and my fellow debaters. And I get to start probably because I have the shortest resume. What we're debating today is whether the government should ever engage in bulk collection of personal data for national security purposes. Our position is that the government should not. This is a hard line. Some of you will agree generally, but not completely, because you worry about some dire situation that might break the rules. I appreciate that. But in our view, that's exactly why most of us were surprised and shocked to learn that the government actually does engage in bulk collection, such as the Section 215 telephony records program, which had been going on essentially in secret since 2001, collecting virtually everyone's phone records in the United States and holding them for at least 5 years. There are a few basic reasons why the government should not engage in bulk collection. Privacy and civil liberties, obviously, and democratic accountability, I think, less obviously. Even if at a policy level, you might agree with what NSA or the FBI seek to do, our constitutional values require public authorization and public evaluation, and that includes the rule of law, the idea that you have courts being able to evaluate according to legal standards what the government is doing. Now, I think there are sort of two fairly common ground doctrinal legal points, at least I hope they're common ground, The first is a concept in the Fourth Amendment about the prohibition on general warrants or general searches. It's widely accepted, the Supreme Court certainly has been repeating this over the last few years, that the main reason why the framers even created the Fourth Amendment was to prevent these so-called blank check warrants and blank check searches that did not constrain the discretion of executive officials in actually carrying out searches and seizures. And of course, the main issue there is that those are indiscriminate, or in the words of the Fourth Amendment, not particular. Now, the modern intelligence community currently seems to define bulk collection as something that is indiscriminate. In a presidential policy directive, it stated that bulk collection is essentially the collection of large quantities of signals intelligence data acquired without the use of discriminants like search terms or names or addresses or phone numbers or other kinds of identifiers. And this, we think, is by definition fits perfectly into sort of the category of general warrants that the framers intended to prohibit. So that alone ought to be enough to say that we should not have any kind of bulk collection. But I'll press that just a little bit. Within that notion of particularity is also a question of who decides. You know, again, because the framers were concerned not only about the bulkness of the collection, about its indiscriminateness, but also about who would be making choices. They didn't like the fact that once the blank check was given to the official, then he or she, well, it would be he, could decide whom to search, for what to take. And so what that tells us is that there's a basic principle here, not only about being particular, about having some kind of selectivity, but also to make sure that we're in a position to really oversee it. We want to constrain it beforehand, and we want to make sure that once it's happened, we actually have a legal rule or a legal standard that we could say, oh, you just broke that constraint. A second principle that I think is inherent in this whole notion of the prohibition of general warrants or general searches is that of proportionality. One of the things that a recent National Research Council study pointed out was that even if you think about this in terms of discriminants, selectors, you've also got a problem in that even if you say, focus on, well, I don't want everyone's phone records, I just want people in California, that's still a huge number. And given the modern bulk collection techniques, it's going to be really easy for those kinds of sort of broad discriminate collection to gather up a lot of innocent people's information. So I want to move then to a more general structural principle about accountability. And that has to do with the whole meaning of national security. The meaning of national security is contested. It's elastic. It fits all sorts of situations. That's what the intelligence community likes about it. And that's what makes it hard for both Congress and the courts to actually control. If you say national security purposes, what does that exclude? It could be anything at any time. So how can you have a rule that's actually going to oversee it? This is compounded by the problems of secrecy, classification of information, which have made it almost impossible for the people to know what it is the government is doing. It even makes it hard for judges and legislators to know what's happening. We've had senators want to talk about what's wrong or what they think is wrong, and yet be unable to do it because of national security concerns about even disclosing the information. So in sum, we've got three big issues. We've got this Fourth Amendment problem with general searches. We've also got the general privacy problem of the information that you've got. And last, you've got this big problem about how are you going to ever govern, cabin, or limit the information or the surveillance if you rest it on national security. I want to mention one other thing, which is that in our own litigation, EFF's litigation on this case, we've also focused on the question of First Amendment associational privacy. That is, our clients are gun groups. They're churches. These folks are chilled by not wanting by knowing that the government is actually inspecting their phone records. Who is calling them? Who is seeking help from them? These are all issues that, and I will stop there. Thank you.
Thank you, Lee. Okay, thank you, Lee Chen. Now, again, we're talking about the government shall never engage in the bulk collection of personal data for national security purposes. And our next debater will be arguing against it, and that's Professor Oren Kerr. Oren?
This side or the other side?
This side.
Thank you, Lance, and my friends, the other debaters here, for being here, in particular the audience members for being here. So privacy, I think we can all agree, is one of our most treasured values. It's essential to a free society. It protects our freedom of thought. It allows us to lead full and meaningful lives. At the same time, the reality is that we face security threats that might be discovered and therefore stopped through some kinds of surveillance. And when deciding what kinds of surveillance our government should engage in, we have to engage in a balancing of interests. We have to assess the benefits of surveillance to the public safety and compare that to the costs of surveillance to privacy. And we should allow the surveillance when the benefits outweigh the costs, and shouldn't do so when the costs outweigh the benefits. This is just a simple cost-benefit framework. I ask you to oppose the motion because it is a harsh, categorical answer to a vague question that doesn't allow the kind of careful cost-benefit analysis that we need. Read the proposed motion carefully. It doesn't say that bulk collection of personal data should require a warrant, or that we should only engage in bulk collection of personal data when necessary. It offers instead a categorical rule. The government should never engage in bulk collection of personal data. Not ever, absolutely, categorically, no matter what. As my friend Lee Chen says for the other side, they are proposing a hard rule, a hard line. Never. You should not enact such a categorical rule, in particular because it's not clear what this categorical rule is. Don't ban something unless you know what it is that you are banning. Consider the category, bulk collection of personal data. First, what is bulk collection? Is bulk collection collecting data on 100 people, 1,000 people, 1 million people? Sure, there will be some circumstances where you can say, well, wherever the line is, we can think of a case that's clearly bulk collection. But if you're considering whether to ban bulk collection of personal data, you need to make sure you know the full scope of what counts. And the nature of the phrase bulk collection is a continuum, not a dividing line. And so you should be wary about banning bulk collection on that ground. And what is personal data? Sure, we can think of some categories of data that count as personal data, maybe your private emails. But what about lists of who traveled outside the United States, or who sent a particular wire transfer? What about records of non-US persons, foreigners, collected abroad? Or consider an old-fashioned telephone book. Imagine you pick up a phone book, or a government agent picks up a phone book. Is that bulk collection of personal data? It's hard to know. The terms here are themselves vague. Even if you get past the question of definition, you should not categorically ban bulk collection of personal data, because there will be programs in which there will be programs where the benefits exceed the costs. For each program, we'd want to know exactly how it works, why it exists, how effective it is, and what are the privacy risks. That's a case-by-case question, and it doesn't allow for a categorical answer. Let me just give one example of what I would think is a bulk collection program of personal data for national security purposes that I think is a good program. The TSA has a program in which they collect the names and birthdays of everyone who flies on any flight, domestic or international. Sounds to me like that's bulk collection. About 1.75 million people fly a day. I think that's a good idea as a program. We all know the connection between air travel and terrorist threats. And one good way to keep bad people off airplanes is to know who wants to get on them. And the program allows that to happen, bulk collection of personal data for national security purposes. Certainly there are other programs that may be more or less effective. Every program is going to be different. Maybe you want to say that we should be skeptical of bulk collection or only allow bulk collection when the case for it is strong. But if that's your view, then you should vote against the proposal, not for the proposal. Because the proposal, again, is a hard-line categorical ban on anything described as bulk collection of personal information. It's also important to realize that privacy can be protected downstream. A surveillance program usually works in 3 steps. First, the data is collected, then it is analyzed, and then information may be disclosed. Any bulk collection program should have strict limits on when the data in the database can be queried and when it can be disclosed. Depending on the case, you might want a program in which data is collected widely, but the government needs to go to court, for example, to search the database, and there may be strict limits on disclosure of the information. That may be the proper response in a particular case in terms of the best policy to maximize the benefits of the surveillance and minimize the privacy risks. Again, that is a matter of how to have bulk collection, not whether to have bulk collection. For all these reasons, I think it's just best to never say never. We don't need a categorical ban with a vague scope that may eliminate a helpful technological tool that could counter real threats in a privacy protective way. And for these reasons, I ask you to vote no on the motion. My friend Li Qian suggests that there may be Fourth Amendment reasons, constitutional reasons, why we can't engage in bulk collection. Well, one answer to that is, of course, if there are constitutional problems with a particular scheme of bulk collection, we should not engage in that bulk collection. We can't. However, the Supreme Court's cases have allowed fairly wide-ranging surveillance systems on the ground that there's no search if the government is collecting non-content information. We don't need to worry about warrants, specific warrants versus general warrants, because no warrant is needed because such programs don't implicate the Fourth Amendment at all. So there are no constitutional concerns in the wide range of these cases where there are constitutional concerns. Of course, the surveillance should not be allowed, but that's a question of when we should engage in bulk collection, not whether. So I urge you to oppose the motion. Thank you.
Thank you, Oren. Okay, as a reminder of what's going on, we're halfway through the opening round of this debate. I'm Lance Hoffman, the moderator, and we have 4 debaters, 2 against 2, 1 lawyer and 1 computer type on either side, arguing it out over this motion. The motion is, again, the government should never engage in the bulk collection of personal data for national security purposes. We've heard from the first 2 debaters. Now on to the third, Chris Soghoian. Chris?
So apparently, when you invite lawyers to a debate, they spend their time arguing over the definitions. I will not be arguing over the definitions of bulk surveillance. Thank you all for joining us here. Every day, the telephone companies in the United States hand over records of all of their customers' telephone communications to the US government. Every day, a gigantic pile of records are provided to the NSA, and this database contains records that reveal who called an abortion clinic, who called a gay bookstore, who called a gun store or a suicide hotline. This database, this massive database of telephone records, a bulk telephone records database, is what law professor Paul Ohm calls a database of ruin, which means that deep within that database is information that could sink us all, or many of us. And in fact, the telephone records database that exists and that we've learned about because of Edward Snowden is just one of many bulk records programs that the US government is engaged in. And programs like this and surveillance that occurs at this scale is problematic for several reasons. And I hope that by explaining these, I will convince you to vote yes on this motion. The first is that the internet and telephone companies that receive surveillance requests from government agencies play an important and vital role in protecting our privacy. Surveillance necessarily involves requests that do not involve the individuals whose information is being requested. When the government goes to Google and asks for a copy of your email, you cannot be present. The government doesn't want to tip off the targets to the investigation. And so the only entity that can possibly be there to say no is the company. Judges are supposed to evaluate the applications, but judges are supposed to be neutral third parties. We actually want someone advocating on behalf of the privacy interests of the user, and the telephone and internet companies play that role. They play an important role as our proxies for privacy. And it's true, in many cases, these companies push back. Sometimes they say, you know what, this is not appropriate. They ask for the orders to be scaled back. They say that they will only hand over certain information for certain dates. And in some cases, they outright refuse and challenge the government and take these things to court. When bulk surveillance takes place, the internet and telephone companies are not able to act as our proxies. They are not able to evaluate every single bit of data that they're going to hand over and say, well, does the government need information about this person or this person? Because they're handing over everything at once. And then the government gets to query that information without that third party being able to push back at a later date. So that's one problem, this lack of a proxy for our interests. There's a second set of problems related to what happens once the data is in the government's hands. The first is that once you have this database, you have this data set of records, there's a huge temptation to use it in new and interesting and potentially problematic ways. So for example, GCHQ, which is the British government's intelligence agency, and NSA, the US government's foreign intelligence agency, engage in bulk collection of internet communications around the world. They have these devices that sit at key locations at telecommunications networks around the world, and they collect everything that goes through those networks. And I think the original motivation was to collect information that was of huge foreign intelligence benefit, things related to terrorism. But once they had this information, they could start to use it in other interesting ways. So for example, over the last couple of years, because of Edward Snowden, we've learned that NSA and GCHQ looked through those records to see if there were terrorist targets who were looking at pornography, because they figured maybe that could be information that they could use to undermine the credibility of people who are advocating for terrorism abroad. GCHQ used their gigantic pile of data to figure out which pages on Facebook were being liked more than anyone else. They built themselves a Facebook like button analytics program where they could see around the world which pages were being liked in real time. They also built themselves a YouTube Trends platform so they could see which videos were getting hot in different regions of the world. Now, maybe that's something that's useful to have and something, no doubt, that many people would like to have access to, but the only reason they could do it was because they had bulk access to everyone's YouTube views and everyone's Facebook likes. These are not the kinds of programs that should be put in place, and certainly they would have never deployed bulk surveillance just to have a Facebook-like analytics program. In addition to those sort of creeping uses, you also have the problem of misuse by agency employees. There is a problem, which is that employees who have access to sensitive and salacious data sometimes look at it for their own prurient reasons. And this happens so frequently that there's a name for it in the intelligence community. It's called love-int. This is what happens when an NSA employee looks through the records of their ex-girlfriend or ex-boyfriend or someone they saw on the subway that looks attractive. There have been investigations into these inappropriate uses. People have been punished within the NSA, but no one has ever been prosecuted for engaging in love-int. And so whatever system of checks and balances we have isn't working. And the third and final reason why I think that bulk collection is inappropriate is because the government cannot protect this data. This is a gigantic, sensitive database of information that shouldn't be put in one place in the first place, but cannot be defended once it's there. The US government has a woeful track record on protecting its own information. In just the last year, the White House and State Department networks have been hacked by the Russian government. Countless US government agencies and contractors have been hacked by the Chinese government, and countless US companies have been hacked by the Syrian Electronic Army and other organizations. At a time when cybersecurity fears are at their high point, we should be keeping less data, not more, because once you keep it, someone will try and steal it. Again, please vote yes for the motion. Thank you.
Thank you, Chris. Again, our motion is the government should never engage in the bulk collection of personal data for national security purposes. And our next debater will be arguing against it, Paul Clark.
Thanks for having me. I actually had to spend some fair amount of time, as Lance would know, actually figuring out and convincing myself that I was on the right side of this issue. And so to that end, I had to distill down the question, being a techie, of what the question actually is, which is, should we ever, as has been pointed out, engage in the collection for national security purposes of personal information? So while I think there are all applications of data that's collected that make us all uncomfortable, not just for national security purposes, I think it's useful to instead think if there's a legitimate one, in which case the proposition that you should never do it is false. And so I turned my attention to a database that I know something about, which is the enforcement integrated database that DHS keeps and includes things like the TSA data that my colleague was speaking of, as well as immigration, customs enforcement, border control, all kinds of enforcement data that people who are detained or arrested by agencies of DHS is collected in a database. And I'm actually, in the interest of full disclosure, involved in litigation to cause them to tell us exactly what the data types are and what the fields of that database are. Having said that, I do not believe that we would be any safer or any better off if we simply deleted that data. In fact, if there is a crisis, and most of us in the audience are old enough to remember at least one, it would actually be irresponsible, in my view, to have deleted that data rather than having controlled access to it. So if we think about data that agencies reasonably need to do their jobs, I mean, we all know the IRS has certain data that they keep on us, and you know, it'd be pretty good from my view if that didn't get released. There are strict laws which control access to it. Social Security Administration has medical data and other types of data on us. They reasonably need that data to perform their mission. So the question is, does DHS, in order to perform its mission, need to maintain this type of bulk collection data to perform its mission? I think unequivocally I can say yes. That if there is a crisis, it's going to be an attack or a threat of an attack that is of sufficient urgency that we want to know who the bad guys are. And not only do we not want to throw away the data on the bad guys, we want to know who went and visited the bad guys in jail, who got them out of jail. And we need to have that data preserved in order to respond to such a crisis. So what my opponent said, that the aggregation of data cannot be defended, I actually take some issue with. If you aggregate the data and instead put strict controls on it, rather than leaving it out in various agencies where it is more likely to be subverted, I believe that you can protect privacy and you can actually manage through legislation access to that data. And furthermore, you can run analytics on that data after it's been de-identified. I can actually remove, as they do with healthcare data, for purposes of running analytics. And then in the event that a severe flag is raised, then I could submit that for approval to go back and remap it to the individual data. This is all technically possible. It's all being done right now with healthcare data, and I think that we don't want to confuse the management of access to data with the collection of data. If we simply delete the data, that is, we don't collect it, rather than strictly legislating access, we will have essentially disarmed ourselves from being able to respond to what we know can be very severe threats.
Thank you, Paul. Okay, we'll now move on to a little back and forth among the debaters. And let me start with tossing out a first question, and then they can go back and forth. I'll try to moderate. We'll go for a few minutes this way, and then open it up to the audience for your questions. But Paul, you sort of you said something about, okay, we can aggregate the data and then de-aggregate it if we have to down the road. And I'm wondering if that's really, if the other side would really agree with that, or they have some issues with that. And this also gets the issue of the proposition. Do you put controls on, or can you even effectively put controls on at time of collection versus time of use? That sort of thing. So I wonder what the response is of Lee or Chris.
Let me go first. So we hear this argument very frequently from both people in the government and people in the private sector. Don't worry, the data is anonymous. Doesn't put anyone's privacy at risk. We hear this from the government in defense of the 215 program. It's just telephone numbers. There's no names attached. Of course, they have reverse phone books like the rest of us do. They can type a telephone number into Google, or they can send a subpoena or an NSL to the phone company. But they say, no, no, don't worry, it's just telephone numbers. Internet advertising companies will say, don't worry, we don't know who these people are. They're just unique identifiers that we put into the cookies. But of course, there are advertising companies that link those cookies back to people's names. There is a strong body of research showing that it is extremely difficult to de-identify data, and that the research is moving in the direction of re-identification. That means if you have a database of information that has allegedly been anonymized or de-identified, researchers are finding more and more ways that you can tie that anonymous data back to someone's name. There have been a number of top research projects done by people like LaTanya Sweeney at Harvard, who was until last year the chief technologist at the FTC. There have been countless real databases that have been re-identified, and the progress of knowledge and research is going in one direction, which is less and less anonymity and more re-identification.
Sure. So make sure everybody can hear me. So yeah, I'd like to respond to that. Actually, the de-identification that I was speaking with and the inference problem that my opponent correctly points out actually have been known since the early 80s, when a good friend of ours, Dorothy Denning, published her book about the data inference problems within databases. And in order to infer, you must have a sufficient number of records in order to do that. So if you de-identify the data before it goes out, and if the data, such as the DHS database that I used as an example, which is not internet connected, is not searchable, and you export that data in the appropriate way, it will not be able to be re-identified. And because you have to simply need enough records and enough information in those records to re-identify it. So if I remove name, date of birth, social security number from people who are arrested's records, the rest of location and gender information and anonymous linkages between those records do not actually make it easy to re-identify at all.
Let me give it back to this side now, if you want to ask a question of the other side or respond further.
Well, I'd just like to point out that most of the re-identification and de-identification issue really rests in how much other information is available, right? You can never tell simply by looking at the data set. What you have to take into account of is what other data is out there. And in the context of our debate, which has to do with the with the bulk collection for national security purposes, I think I have to assume that when we're talking about the ability of the intelligence community and the national security establishment to re-identify or to actually use that kind of data, they already have their hands on an enormous amount of data, even without bulk collection techniques. Plus, some data is simply, it's hard to, say, de-identify DNA. It's hard to de-identify location records. The most recent studies show that something like a minimal set of 4 location points, and this is taken from studies involving cell phone, mobile phone location, is enough to uniquely identify individuals, at least inside the United States. So the amount of data that's needed to really penetrate a lot of these, the supposed anonymity protections in these data sets is very, very small. And when you look at the threat model, which is the intelligence community being able to use this data. I think it's very, very difficult to actually, for them to ever claim that they would not be able to actually identify people.
Let me ask this side over here, Paul and Oren, would this change significantly if the proposition were not about the government, but were about the private sector? In terms of collection?
So you're asking, would the merits of the question change if it were private sector
Yes.
bulk collection of personal data for national security purposes?
Ah, that's good. You go with what you want with that.
So well, this is,
They're done.
I mean, my instincts are the same, that never say never. We need to analyze the merits of any particular program on a case-by-case basis, looking at the actual data that's being collected, how it can be secured, how it may not be secured, what are the risks, what's the oversight, what are the audit systems that are in place. We need that on a case-by-case basis. I mean, I think the default, of course, in the context of private sector collection is that unless the law steps in and says you can't do it, private companies, that's just a matter of they can collect information from their customers, usually pursuant to some sort of consent, or they have somehow registered with a private company and they are giving their data to the company. So I think it all just depends on the case. We shouldn't be answering this question in bulk, maybe is the best way of thinking about it. We need a granular answer to each program and to figure out whether it's a good idea or a bad idea.
Moreover, in order to find against the proposition, you only need to find one counterexample. I'll point out that the database that I've been talking about includes no cell phone records. It simply keeps information on known bad guys. And so to that end, we only need to look at one legitimate use of this information in order to find against the proposition.
Does this change? Oh, go ahead, Chris.
So after you guys vote a second time, the votes will be counted, and then it'll be put onto the internet. And we're having an in-depth debate here, a refined debate with my opponents, delving into these small programs like TSA's database. But if you vote for them, when this is printed on the internet, it won't be, an audience at George Washington favors bulk collection of a limited database maintained by TSA. You have to understand the greater context that this debate is taking place in. Right now, the law that the government is using to collect bulk telephone records is expiring. There are debates on the Hill today to discuss whether or not this law should be renewed, whether or not the government, whether or not federal agencies should have the ability to go to private parties and compel the disclosure of all records about their customers. And so whatever you do today will play a part in that debate, in that broader political debate. This isn't about TSA collecting names and telephone numbers. This isn't about US Customs collecting information. This debate at its core is about secret databases maintained by the government, compelling third parties into handing over our private data to the government. This is not about someone filling out a form at the airport. All right? And so be very, very careful. Do not let the other side twist this and make you think that, oh, I guess there's this one database that the government keeps that sort of sounds okay, so therefore I'm going to bless what they're saying. This is a chance for you to say no to what the NSA is doing, and so please vote yes.
Before I was a law professor, I was a prosecutor at the Justice Department, did a couple jury trials, and there's a name that lawyers have for the argument that Chris just made, and it's called jury nullification. That is, don't answer the question before you think of the symbol that your decision will send to the public at large. I think we're here to answer the question before us, which is, should the government ever engage in bulk collection of personal data for national security purposes? And you should focus on that question, not whether you like Section 215, whether you want to send a message to President Obama, whatever your broader views are, this should be focused on the question before us today.
Well, I've got to respond to that. I mean, again, I keep going back to the Constitution. And the reason I keep going back to the Constitution is that I think that it represents sort of the basic charter for our principles. And one of those basic principles is that we don't actually trust the government to do the right thing. That's why we have separation of powers. That's why the executive branch is not supposed to be a king. That's why Congress is supposed to make laws, and the courts are supposed to figure out whether or not things are actually in accordance with the law and with the Constitution. Now, Orrin and Paul have been talking about, gee, you know, you've got to look at this on a case-by-case basis. But, you know, like I said at the beginning, looking at things at a case-by-case basis is kind of what got us to this state right now. We are debating the question of whether or not the government should be engaging ever in bulk collection, because we've never actually apparently said the government never should. And so, as the executive branch, and especially the national security establishment is wont to do, they have taken what seems to be a soft spot and just run the hell out of it. And they will continue to do that. And that's why I keep saying, you know, if you are looking at what the rule should be, what our principle should be, then it should be no, because that doesn't give them the flexibility to choose to do things, which I might add, obviously, they have been doing in secret precisely because they do not want actually the public and the courts and the Congress in full knowledge to understand what's going on. In fact, I don't know how we can even do the kind of granular case-by-case analysis that Orrin and Paul are talking about if we don't have facts about what the government is doing, and we don't have a clear understanding of what the rules of the game are. We have seen with the 215 program, just as an example, that the law, which contained the word relevance, which has always been understood to actually limit what the government is supposed to be able to collect, as opposed to collecting everything, got turned into a blank check to collect all or as many telephone records as they could on the rationale that only by having it all would you be able to trace certain kinds of patterns. So the entire tone of this exceptions-based argument is actually to create a loophole that the intelligence community has and will continue to exploit unless it's closed.
I agree with a lot of what Lee just said about transparency and disclosure. I think it's absolutely essential that the public debate these questions as we are here. I think it's important that Congress now knows that the Section 215 telephony metadata program is existing, that authority is about to sunset. It will sunset on June 1st, and Congress will decide whether they want to reauthorize it. And I think we should harshly criticize the Foreign Intelligence Surveillance Court for approving a program based on, to my mind, a fairly flimsy statutory interpretation. They basically allowed this program based on a reading of the Foreign Intelligence Surveillance laws, which you couldn't have gotten if you just read the text, and that's what the text is there for, to limit the executive branch. So I agree the Foreign Intelligence Surveillance Court was improperly read the statute, and we should criticize them for it, and that we should have a public debate about the nature of these programs. But again, and I hate to be the law professor, but I guess that's my role, that's a question about how we should do bulk collection. That's not a question of whether to do bulk collection, or at least the question of disclosure is separate from the merits of the idea of the program. So I join Lee in saying that this should be a public debate, and it shouldn't be a secret program, but I still think we need to debate each program, and the way to do that is to do so publicly, but still to not have a categorical ban.
Can I just quickly add something, which is that Orrin's using program in the singular, but there are many programs, and we only know about one of them. The government has said that there are other bulk collection programs that are taking place using 215, but we don't know what they are. They've said that the majority of the 215 orders relate to some kind of cybersecurity program, but we have no idea what kind of data they're collecting and who they're collecting it from. They're likely collecting hotel records and records of certain kinds of purchases from certain merchants. I mean, 2 years on, 2 years after Snowden, we still don't even have an idea as to how they're using this much debated law. And so I think the point from that is that they're not going to tell us ever. The only reason we know about the telephone program is because of Edward Snowden. Unless we have a whistleblower every year, we are not going to learn about the basics of the bulk collection programs that the government is using. The only way that we can control them is to say no to bulk surveillance, because after the programs come into existence, they live in the shadows.
So as a techie and a linear thinker, I think I've heard the question we're debating changed a few times to a point that we can all agree on, which is we're all uncomfortable with bulk surveillance. We're all uncomfortable with government agencies not having access to data that they need to perform their missions. I've heard, I think, Lee say that the default should be no. I think that's probably a reasonable position. The question before us is, should it ever happen? And to convince myself of that, I found a program that I believe is still on the table that doesn't require cell phone records. It doesn't, is it subject to abuse? To be sure. But I think that eliminating data rather than managing access to it needlessly disarms us. And I think that we can all construct an example, however severe you need to make it, where we're willing to surrender privacy rights in order to protect ourselves. So deleting the data would prevent us from doing that rather than managing it.
Let me ask one more question, starting with this side, and then we'll get to your questions. So think about questions you may wish to ask, and also we're going to have the second vote in a few minutes. And to that, I ask my SFS students to hopefully they've tallied the first vote and to come down and give them to me when I'm not doing this, so I know what the first vote was at least. Okay, would this change at all? Fast forward, we're already in this mode, but fast forward 10 years where we've got the Internet of Things, really big time, and everything is talking to every other thing. Does this change your argument at all? Make it worse, make it better? Are there other opportunities for your side to prevail in this new environment or not?
I have an internet-connected thermostat in my house, and at some point I will likely have an internet-connected home surveillance system surveilling people trying to get into the house. I will likely have an internet-connected washing machine at some point in the future, and I'm fighting the urge, but eventually I will probably have an internet-connected TV. And all of these devices are creating data that can be used to reveal when I'm home, when I'm not at home, who I'm at home with, what I'm doing in my house. And this is data that doesn't reside in my home. This is data that leaves my house and enters the databases of third-party companies like Google and Facebook and Microsoft. These companies pledge that they will protect my privacy. They pledge that they will evaluate every request that comes in and push back against requests that seem unreasonable. But they cannot push back on bulk orders if courts rule that those bulk orders are lawful. And so we may move to a point in the future where Nest, which is owned by Google, has to hand over bulk records of everyone's home power usage, revealing when they leave, when they come back, when they decide to turn the temperature up and down. We may move to a point where Google also owns a home surveillance camera service as well. That camera footage may be handed over in bulk. I think the Internet of Things really just moves us to a world where the government has so much more data. And if bulk surveillance of telephone communications is possible, if bulk surveillance of location data is lawful, then I don't see why bulk surveillance of power usage wouldn't be lawful. I don't see why bulk surveillance of transit system movement wouldn't be lawful. And I think that's information that the government hasn't had in the past at that scale, and it's information they shouldn't have in the future. I don't want to live in that kind of world. Certainly, I didn't sign up for that, and my member hasn't voted in favor of that. And I just think it allows the government to have too much information about too many people who've done nothing to deserve that level of inquiry into their private lives.
Do you mind if I add to that before?
Go ahead.
Yeah, so the thing that's interesting here is that there will be much more data. Of course, there is already an enormous amount of data to go after. The thing that we haven't talked about, but that will, I think, become more clear with more data, is how much more data there will be available without engaging in bulk collection. And, because the question is really, can we do things the right way? And it will actually, I think, as a practical matter, we can do things the right way now, but it will actually, or it may actually be easier to do things in a targeted way.
For the government.
Yes, for the government. And so right now, the way that the debate is being framed, it's sort of like, well, gee, if they can't do that, then we'll lose X, Y, and Z. It's actually sort of hard for me to gauge, because I think the privacy threat is far, far greater with much, much more granular transactional data created by the Internet of Things. But at the same time, it may actually be easier for the government's, say, investigative needs to be satisfied without engaging in this sort of poisonous tool. Unfortunately, we're in the current situation, we're all being sort of told, or at least being led to fear, that things will be lost that we must not lose if we don't do this, even though, quite frankly, we have very little idea what the delta is between the bulk surveillance and a surveillance that would not be bulk. They are not telling us that. I actually have a lot of skepticism about whether there's anything much to lose at all.
When I think of the impact of the Internet of Things on this question, I think, okay, there's going to be a lot more information that's going to be collected by private parties that will be out there, regardless of what the government does. And then the question is, are there any data sets where some sort of widespread collection of that data set would have a substantial role in advancing public safety and yet not pose a significant security threat? I don't know what those data sets would be. If the question is, is your thermostat connected to the internet? I can't imagine how bulk collection of thermostat data is going to somehow protect the country against terrorist threats. And my position is not that we should engage in bulk collection of everything, remember. It's just, should we ever have any kind of bulk collection? So the availability of new kinds of data, I'm not suggesting there should be bulk collection of that. That's just a question of what the private sector is doing outside of this. I did want to address Chris's point. Chris says that it's better to have the government going to the private party and seeking collection piece by piece of information, because the private party can fight that acquisition of the information. And that if you have bulk collection, then the private party is no longer able to do that. And I disagree with that for a couple of reasons. One is that, of course, the private party can fight the bulk collection. There are still continuing orders, typically, which are requiring the private parties to hand over the information, and they can fight those. And then also, once the information is collected by the government, you can have significant legal regulation of government access to the database. So, for example, in the Section 215 program, the way the program works now, the government goes to a court, goes to the Foreign Intelligence Surveillance Court, and says, we want to send the following query, and then the court will approve or disapprove the court order in that context. Essentially kind of like the traditional warrant procedure where a government official has to go to a judge. And we can argue about what the standard should be for querying the database, but that's the pushback is from the judge who says, you have to satisfy the standard to get access to the database. And that's essentially the same privacy protection regardless of whether the government has the database or the private sector has the database. And I think it's a fair question, which is the more or less secure approach? Are private companies that have a database in their, on their servers, are they more or less secure than the NSA keeping it where they may have invested more resources and have more of an incentive to invest resources on the security of their data? So it's not clear to me there's actually that much of a difference between bulk collection where the government goes and gets a court order versus the private companies keeping the data and then the government getting the data on a more individualized basis.
Can I push back against Oren's point, since he called me out by name? That's fine. The way that Oren describes it, the government collects this information under somewhat suspicious circumstances, but then they have this strict set of rules that govern when they look through it. And those rules can act as a sufficient check and balance to make up for the total absence of effective rules at the front. It's true that with the 215 program, it has been blessed by the secret FISA court, but that is not the only bulk surveillance program that the NSA operates. In fact, the most problematic bulk surveillance database that the NSA operates is one called XKeyscore, which is a bulk surveillance database of internet communications collected around the world, and no judge has to evaluate or sign off on queries through XKeyscore. It's through that database that the NSA and GCHQ looked for records of people looking at pornography. It's through that database that GCHQ and NSA stalked and hunted engineers at Gemalto, a Dutch-French manufacturer of SIM cards, so they could then hack into that company and steal encryption keys. It's through that database that much of what NSA does is possible. The surveillance that NSA conducts abroad, which is bulk surveillance at its largest scale, is really a system with no checks and balances. It is the Wild West of surveillance. And what it demonstrates is that these rules don't come along automatically. They have to be put into place, and we are going to get the fewest rules over bulk surveillance programs as opposed to individual requests for individual users' data. Everything that NSA does, I think, terrifies me, but of all the things that they do, the collection under Executive Order 12333, of which XKeyscore is one component, that is the part that really terrifies me. And I think it should terrify us all because we know so little about it. There are no FISA court orders authorizing it. There are no FISA court search warrants authorizing searches through it. It's just a massive pool of data, and government agents can just put a net in and pull stuff out. And it turns out when you have this gigantic data set of people's emails and web browsing records and other private information, there's going to be some useful stuff in there. But it's too attractive. It's too tempting for them to use it. There's always one more use. There's always one more interesting thing they can search for, and there are so few controls over the collection or the use.
Okay, Paul, you get the last word, if you want to.
As a techie, I think we've gone off course again, but I wanted to say in support of what Oren was saying that absolutely, unequivocally, I can tell you that a private company connected to the internet with internet-connected databases is less secure than a physically secured facility with a database that is not connected to the outside network.
Okay, thank you. And with that, we'll move on to the questions. If you have a question, I hope some of you do, please, we have some microphones. Where are they? Who has? Oh, okay. So we have some microphones in the back. Please raise your hand, and somebody will come down and approach you and give you the microphone. And
today we have cameras in airports, malls, stadiums, collecting information to everybody that walks by. There's been talk about government expanding that so you can actually have more cameras in the public. Now, understanding that those kind of cameras could have unraveled this mystery around Trayvon Martin and the Jefferson, Missouri incidents, would you be against that as well?
Who's the question to?
Chris and Lee.
So I think cameras everywhere. Go ahead. All right, so I didn't hear all of the question, but
you want to repeat it real quickly?
Yeah, bulk collection via cameras in the public.
But government-owned cameras or private-owned cameras?
Well, a little of both. Of course, the government could have access to the video streaming from the private networks as well.
Are you holding the microphone, by the way? I can't tell.
Now he's empty-handed.
Well,
But
let's do it. One
I think
more-
I got the question.
I'm saying that they could uncover mysteries
All right.
that exist that did have cameras. Would you be against that type of collection?
So I think the thing is that I don't think there's anyone on stage here who would say that bulk surveillance data wouldn't be useful to the government, right? Let's just use this as a thought experiment. If the police could kick down any door they wanted and search any home anytime, they would certainly be able to catch more bad guys. That I don't think there's anyone who would say, no, it'd actually make it more difficult for the police to catch bad guys. If they could search everyone all the time, search people on the street, search their bags, search their computers, search their houses, with no court order, with no judicial supervision, of course it would be easier for the police to catch bad guys. And of course, there are more bad guys
I'm sorry,
on the street
give him
today.
the microphone, please.
There are more bad guys on the street today because the police have to follow rules and get warrants. But our founding fathers didn't want that kind of system.
You shifted the question.
All
I
right, hold
talked
on, we're
about
gonna go,
public.
we're not, you get one question, there'll be another 30 seconds there.
Yeah,
and
just
another
public.
1 minute here, and then we're gonna go to the
Public
next one.
surveillance. I didn't say kicking down any doors.
Well, no, what I'm saying is we can make the government's job easier by removing all of our privacy protections, but our founding fathers didn't want that. And there are countries where there are cameras on every corner, the UK being one of them, and the UK and Singapore, which also has them. They're both police states. And I'm not terribly excited about the prospect of living in a world where a camera captures every single movement, every person I'm holding hands with, every person I whisper into their ear or kiss them on the cheek. I think there are private moments that the government should never be able to monitor. And yeah, you're right. We're heading into a world with more cameras, some of which are going to be installed by the government, some of which are going to be installed, when there's a Super Bowl or a political convention in your town, and suddenly DHS pays for cameras everywhere. And some of the cameras are going to be because we install them or because businesses install them, and they'll be centralized and data will be pooled, and the government will be able to obtain that, and that terrifies me.
All right,
and I
Chris?
think that we should make it more difficult for the state, and we should require that they have to get individualized warrants for individual sets of data, because otherwise it takes us down this terrible path to a surveillance state.
Okay, let's move on to hopefully another question. If not, I'll have to ask one, I guess, or Ernest down in front.
Ernest McDuffie, CEO of the Global McDuffie Group. So I've done a lot of work in cybersecurity issues. Actually worked for NSA as I guess a disclaimer. I have a military background. So the thing that this question does for me is, the focus on never. I think that's a big point. I hate anything.
Again,
that
Ernest,
says
it's not
never.
a speech, it's a question.
No, I know. So the question is, what do you do about the bad guys in the world? We're kind of coaching the government as being the bad guys. I take that you can't trust the government to some extent. That's why the checks and balances are part of the system, so that there is some degree of trust. But you certainly can't trust the bad guys. All the technology that you're talking about is out there and available to them, and they're going to use it regardless of what you do on any of the laws. So
So what's your question?
The effect is, do you feel that the handicapping of the government in the face of the threats and knowing what out there is worth it? Is it worth the risk of multiple 9/11s every day because you didn't do bulk collection?
Okay, Lee, you want to try that?
Well, there's as Chris was saying, one of the basic issues here is how much are you actually going to take away the restrictions that we have had on government. I mean, it is, I'm repeating what Chris said, but it's always going to be easier if you can always make it easier on the government, right? And you will have presumably some increase, perhaps, in crime fighting or terrorism fighting capacity. But we're not saying, and the proposition doesn't require us to disarm ourselves in terms of fighting crime or terrorism. It is only saying that one of the key things that this country was founded on, the idea that you do not have bulk collection, that you do not have general warrants and general searches, that you do not have indiscriminate exercise of surveillance power by the government, especially when it's in the hands of individual agents who can do what they want. That's the proposition we've got here. And I think that it's actually giving the NSA and giving the bad guys way too much credit to suggest that the only way that we can, as a society, as a nation, as a world, actually live is by becoming a surveillance state. I mean, I don't like slippery slope arguments, but bulk collection is, sort of in and of itself, the end of the slippery slope. It is to say that you can collect indiscriminately without regard to whether people have done anything
Lee,
wrong.
Lee, I'm going to stop you now because
So I'll just stop there.
because you have a closing argument coming up. Is there anybody with a question for the other side here?
Thank you. My question is mostly for Professor Kerr.
Identify yourself first.
William Yeomans. I'm a faculty member at the School of Media and Public Affairs. Without getting into the specific word of never, I'm interested in your idea of a cost-benefit sort of approach. Almost like an actuarial kind of approach, looking at a calculation of risk. Is there a threshold of risk that you have in mind that would justify that kind of program, like a some sort of cut-off level where the benefit justifies the kind of cost? Because that's the kind of the conversation that I think your point would have to get us into. So it's kind of a vague question, but if you could give me a sense of what kind of ratio you think would be ideal.
Great. So I think that there's so many uncertainties about the nature of the security threat, about whether any particular tool is going to be useful, was useful in the past, may be useful in the future, what the security risks might end up being, will information be disclosed, to what extent, what security mechanisms are the best ways. It's hard to make it, it's sort of hard to go to numbers because of the uncertainties. What I'm thinking is more just from almost a common sense of, okay, we might engage in a surveillance program. Is this going to be worth it? Is it going to work, first of all? I mean, it may be that a particular surveillance program just doesn't work. It doesn't particularly yield helpful intelligence information, and then it should be stopped. On the other hand, it may be that the program say, wait a minute, this actually is really valuable. This turns out to be an effective way of finding whether it's terrorist cells or transactions, financial transactions, or whatever the thing is that the government is looking for. And so we should never think, oh, well, categorically we want bulk surveillance or we don't want bulk surveillance. Just what kind of surveillance, what kind of information, how's it going to be protected, and that we need to always be kind of keeping that cost-benefit issue in mind.
Paul, you want to respond to that, or has Oren said what you want to say?
No, I've already said.
You've already said, okay. I see no other questions, so I'm going to move on. I want to thank you all for your questions so far. We're now going to hear the closing statements, which will be very brief, just 1 minute each, and 4 minutes from now, we'll be voting. So remember how you voted before? Maybe your mind has changed, maybe it hasn't. And 2 minutes after that, we'll get the results. So let's go to the first person, the closing argument. Again, the motion is the government should never engage in the bulk collection of personal data for national security purposes. And here to summarize his position supporting the motion is Lee Chen. Okay, Oren, you want to summarize your...
The premise of this debate is that we've entered a pretty scary world, scary in two different ways. Scary in the sense that the threat of security harms is real, and also scary in the sense that the privacy harms, the privacy threats are real. We've entered a world of data, and we're trying to figure out what to do with that world of data. There's just so much information out there, and as we look out into the future, there's just more and more information available, and we're just trying to figure out, what do we do with that? What should the government have access to? Under what conditions? My view ultimately is you should vote against the proposal because we shouldn't shut the door to whatever counts as bulk collection of personal data. We should look at each case on a case-by-case basis and not foreclose the possibility some of these programs are going to be pretty effective and useful and therefore worth it. Thank you.
When Section 215 of the Patriot Act was passed, the public was told that it would be used to get records from rental car companies, The big debate at the time was over whether the law could be used to get library records. The American public was never told that this law would be used to get telephone records in bulk. The only reason we know about this bulk telephone records program is because of Edward Snowden, and we still don't know about several other programs that the US government is operating. The fact is, we are never going to be told about the bulk surveillance programs that are the most problematic. We don't get to have a fine-grained analysis or to do a case-by-case analysis because we are not part of that discussion. As citizens of this country, the only way we get to have a voice is at the high level. The only way we get to say no is to say no to all bulk collection, because we're not going to be in the room when these secret interpretations of the laws, of our existing laws, are getting discussed and approved. The way to say no to the most problematic bulk surveillance programs is to say no to all bulk surveillance. And so I ask you, please vote yes.
First, thanks for having me. I've actually really enjoyed this. I think that the argument as it was originally posed and presented still comes down to the fact, is there a case when it should be allowed? I've presented one. My opponents none of them have told you that that database should be deleted. Not one of them. And I think that there are, in order to perform the operations of these agencies, legitimate reasons for them to collect data. And so the question is whether that data should be retained for national security purposes. I didn't hear anybody say that it should be deleted. Thanks.
Okay, thank you all. And now it's time to learn which side has argued most persuasively. We're going to ask you to go ahead and go to your 3x5 cards, which you have, the other set of 3x5 cards, and vote a second time. Remember, it's the team whose numbers have changed the most in percentage points between the opening and closing, which will be declared the winner. If you agree with the motion that the government should never engage in the bulk collection of personal data for national security purposes, we're asking you to check the agree box. If you disagree, check disagree. If you remain undecided or became undecided, check the undecided box. Pass the 3x5 cards once you check them over to the aisle again, where some of our students will come by and collect them again and bring them to a central place, count them very quickly, and then we'll announce the results in really just a couple of minutes. So everybody have their votes done? You can't vote the second time if you didn't vote the first time, by the way. Okay, pass them over to the aisle. And then once you guys get done counting them in the back, just bring up to me the results up here. In the meantime, I will mention it's been really fascinating to see these four experts talk amongst each other in a very respectful and civil way about this, even though they disagreed with each other. Let's give them a round of applause for their efforts. Okay, and while we're doing that, a word from our sponsor. I have to vamp for a couple minutes while the votes are being counted. So I thought I would talk just a bit about the Institute, the Cybersecurity Policy and Research Institute, which I direct, which is one of the sponsors of the University Seminar Series, or one of the organizations along with SMPA and the School of Media and Public Affairs and the Elliott School of International Affairs and the Law School, who are bring this to you. CSPRI, the Cybersecurity Policy and Research Institute, is in the School of Engineering and Applied Science, but we really do all of the missions of the university in terms of research and education and service. We have projects in each, as you can see there. Indeed, this project is one of them. If I can ask the mouse click on the first slide, on the first blue bottom there, the blue box, the University Seminar on Internet Freedom and Governance, that's what this is. You see the mouse creeping up there? And in a moment, you may have seen this. And now, talk about recursion. This is a live stream of a live stream or something like that. This is pretty cool. So that's this project. And then if you would go back, please, to the original, that slide. Thank you. We also have a scholarship program. Many of the students here are in the CyberCore Scholarship Program. It right now supports students in 4 different schools of the 10 schools of the university. And next year, it'll likely support students in 5 schools of the university. And that's really quite something, because cybersecurity really is interdisciplinary, and cybersecurity and privacy, closely related, as you can tell, really are important, interesting, and so interdisciplinary and multifaceted. That's the website of the CyberCorps Scholarship for Service program up there. And if I can go back to the original one, do you have the results? Ah, the results are in, okay. We go back to the original slide then, of the sponsor slide. Come on up and let me see these. Thank you. Okay, now I get to reveal, in the beginning, we started out, and again, the proposition is the government should never engage in the bulk collection of personal data for national security purposes. Okay, never engage in it. At the beginning, believe it or not, of the 20 people that voted, okay, it was basically even. There were 7 yes and 7 no and 6 maybe. Okay, that was in the beginning. Now, at the end, there was only 1 maybe. And there were now, at the end, there were 6 yes and 11 no. So the no's have won, okay? So congratulations to the no's, and congratulations to everybody. Give them another round of applause. Thank you very much for attending. This will conclude the main live portion of the debate, and if you want to come down and meet the speakers or talk to them, they'll be here for a few minutes. Thanks very much.